Thanks very much, Chairperson. I'm going to try and be very summary, fairly brief, and hopefully during the course of the discussion, we'll have an opportunity um, to elaborate on some of these issues. Just to start off by making some points that have been made before, just very summarily, that in fact, the question of governance of state enterprises is rather more important than in the context of private companies. And this is because, as has been said before, we are talking about dealing with taxpayers' money. And so therefore, I think that it's reasonable that we should expect that state-owned enterprises should be held to an even higher standard of governance than private companies. But the reality is that state-owned enterprises, not just in Trinidad, we know the situation in Jamaica, but it's a global problem. Many countries around the world, we have a situation where state-owned enterprises actually tend to have a lower standard of transparency, accountability, and performance than companies in the private sector. And a lot of ink has been spilled on, not actually spilled, but expended on the reasons why in fact that is so. In the context of Trinidad and Tobago, we have had several different committees that have looked at the question of state enterprise performance, and these issues going back to, from my own memory, the first committee that I served on in that regard was 1985, was the Bob Committee in 1985, which looked at that. Then there was the Rampersad Committee, which was around 1989 into 1991, did an extremely extensive report. And then my own committee, which worked on in 2016 on the wholly owned state enterprises. The second point that I'd want to make is that the problem that we have with state enterprises is that they are political. They are formed by government. They are supposed to be formed by government for ostensibly for a public purpose. We can question whether or not there is a valid public purpose, which is the approach that my committee took to looking at the portfolio of state enterprises. But one of the philosophical approaches to the questions of should you have a state enterprise at all is whether or not that public purpose which the government would like to achieve cannot be achieved by some other mechanism, by some other means. In other words, one of the things that I guess we economists would say is that if you believe that the market can and do most things more efficiently than the public sector can, then what you would argue is that the first thing that you should do is to try, if the market is not producing the result that you want, the first thing that you should do is to regulate the market. So the first port of call where you have a distortion of market, or what economists call market failure, ought to be regulation. Sometimes regulation is not appropriate or can be ineffective. So we have quintessential regulators, for example, like central banks, and we have financial services commissions, and we have public utility regulators and so on. And what they do is that they attempt to regulate particular entities and so on. And if regulation is inadequate for the particular purpose, public purpose that you want to address, and the particular market failure that you want to address, then you might want to look at the creation of some kind of state entity to essentially take the role or take on the role of the provision of the particular goods or services that you require. Now, having said that, I want to make a distinction that's important. I think maybe Camille Facey this morning was talking about the fact that in Jamaica has about 90-something of these, what they call public bodies. And most of the Jamaican public bodies are in fact established by statute. They have very few companies that are formed as limited liability companies under their company's ordinance. In Trinidad and Tobago, this is not the case. In Trinidad and Tobago, there has been a very deliberate, starting from around the 1990s, a very deliberate choice made by the government to choose the limited liability company as the vehicle. So we have actually created state enterprises which are formed under the Companies Act. We also have statutory bodies. That's to say we have entities or corporations, I would like to call them statutory corporations, that are created by statute. So we have legislation that sets them up. And then we have a bunch of statutory, what we call statutory bodies in Trinidad, which are set up in some cases by statute, but they are not corporations in the same sense. So they might be utilities, for example, or Water and Sewerage Authority. The Tea and Tech is a commission, which is a very interesting structure all by itself. So we have these different types of how should I put it, of corporate structures, but which all have the same basis that they are owned by the state. The distinction is important because in the case of those that are formed under the Companies Act, the owner of the company, the shareholder of the company, is the Minister of Finance Corporation sole. It is not the Minister of Finance. It is the Minister of Finance Corporation sole, because we have legislation that establishes the Minister of Finance Corporation sole as the owner of these state enterprises. In the case of statutory corporations, most of the legislation establishing the statutory corporations actually give the line minister for that particular corporation certain kinds of authorities. And in fact, for the lawyers present, the legislation that we have usually allows that line minister to give that corporation specific directions. Now, this is, I think for the lawyers would appreciate, this is a very important distinction. It's not a question of giving general directions. It's a question that they can give a statutory corporation a specific direction. And therefore, that has implications for a board that you put in place to run this particular statutory corporation. And we can talk a little bit more about that later on. The second point that I want to make is that whether you statutory corporation, statutory body, or a state enterprise, strictly speaking, the governance structure that we have for these entities in Trinidad and Tobago, and I dare say elsewhere, is very complicated. At the top of the hierarchy, and this comes out of a diagram which is actually represented in the state enterprise performance manual. So it's how the government acknowledges that it governs these entities. And at the top of the hierarchy is the cabinet. So there is a recognition that the cabinet, the government, the minister of government sitting in cabinet, have a governance responsibility for these entities. And it goes through to the line minister, to the line ministry, because some enterprises do particular things that fall under line ministries. You will have the Minister of Finance Corporation sole, in the case of state enterprises. You'd have the investment division of the Ministry of Finance, and then you have the board of directors. And that structure is obviously from the point of view of a state enterprise where you are operating under the Companies Act and nothing else, quite frankly. In other words, nothing else. There is no other legal, how should I put it, framework that guides state enterprises other than the Companies Act. They do have a state enterprise performance manual, but that is a document that is there, and I would dare say, if in particular circumstances, if there is a challenge whether or not a director carries on certain duties or does not carry on certain duties, that it is going to be the legislation, the Companies Act, that is going to prevail in terms of what they can do and what they cannot do. So we have a very complicated structure. The other complication that we have is that because government is the owner, governments have multiple objectives. Governments are responsible for all kinds of things, including promoting growth, including law and order, and so on and so forth. And the objective may not necessarily be profit maximization. So you can set up an enterprise, and a good example would be an entity like CAL, for example, the airline, and which as a member of the BWI task force in 2005, 2006, I had some responsibility for working on the recommendations for the creation of Caribbean Airlines. And why it is, from a strategic public purpose point of view, there was the notion that you needed to have an airline that operated under the Companies Act that would fly in competition with airlines from all over the place, with JetBlue and with everybody else and so on, right? But the objective in respect of CAL, for example, is that I have never heard that people would say that CAL must make a profit. I think that they're more concerned about the fact that CAL does not make a loss, okay? And from my perspective, that's a perfectly valid objective that you might have for an entity like CAL. In other words, it must not make a loss because it is providing you, it is meeting a certain set of strategic objectives in relation to air travel and access to the country, which is important from the country's strategic point of view. But governments also play the role of regulators and of policymakers and so on. And the point I'm making here is that these objectives of government, these multiple objectives that governments have, may in fact conflict with each other. The government's role as regulator may conflict with its role of the ownership of an enterprise. Let me give one classic example of that in Trinidad and Tobago context, and that has to do with an entity here which we have called the National Gas Company, which sits between the upstream producers and the downstream petrochemical companies. So it's a company under the Companies Act. And the real purpose of the NGC, if I may say so, is to assist the government in extracting value out of the energy sector and transferring that value to the treasury. That's what it's there for. But the government, in respect of the energy sector, also plays the role of regulator, because here is an industry that produces the country's oil and gas, that has environmental impacts, that has impacts in relation to, as we've discovered recently with the whole Venezuelan brouhaha about selling oil to the Venezuelans, foreign policy implications, all kinds of things. So you can have situations where the government's objectives in respect of its role as a regulator or in respect of other aspects of policy may conflict with the objective of the state enterprise. So we are dealing, governance in state enterprises can be extremely difficult. Let me touch on a couple of other points relating to directors. And Mr. Dipam this morning made some very important points about the question of selection of directors. It is a perennial problem. It has been actually been commented on in a court case in Trinidad and Tobago by a court of appeal judge who's actually now a judge on the CCJ, Maureen Rajnat-Lee, who actually pointed out that in Trinidad and Tobago, people are selected on boards because of their connection with the political party. And as Donald pointed out, our situation in Trinidad is exactly the same as the situation that obtained in Curacao prior to 2010, where when the governments change a general election, everybody on the board of the state enterprise resigns. And there is this presumption that they are there for all political appointees. We also have a situation where, in respect of directors' competence to be on that board, in other words, whether they bring to that board the sets of skills and knowledge and so on that is required for the effective oversight of the operations of that entity, is questionable in many of the cases that we looked at when we did our report in 2016. So to summarize, there are some critical points of failure, and we could elaborate in the discussion, that we have in respect of state enterprise governance. Failures can result from what I call poor routine governance practices. In other words, things that we take for granted. You have to have board meetings, there must be a certain periodicity, you must have proper minutes, and those kind of things that we take for granted because that's how we operate. We find that in many of these state enterprises, particularly the smaller ones, that routine governance, producing timely minutes, filing your annual returns on time, compliance with many of the statutory requirements as well as the requirements of the investment division of the Ministry of Finance are not complied with. So routine governance. Secondly, the actions or directions of the cabinet itself. We have situations we know where cabinet gives directives to enterprises. They give the directive through the chairman, they may give the directive through the CEO, they may give the directive to anybody, right? And these things are done by somebody picking up the phone and calling. Nothing is ever written down, nothing is ever minuted that you can see, but we do know that these things happen in these enterprises. There may be actions and directions of the line ministry. There may be the conduct of the chairman of the board. In other words, we can have situations where, I think one of the points that Donald made this morning in respect of the Curacao operations is a situation where you have many different ministers attempting, over a period of time, attempting to, or being in charge of or responsible for a particular enterprise. We have had that situation in Trinidad, where over the period of about 3 years, we had about 3 or 4 different ministers of tourism, right? All responsible for the tourism development company, right? So in that kind of situation, the board is obviously confused because the minister is supposed to give policy direction and so on. And finally, we have the question of the conduct of executive management of the entity itself. And we have had instances here in Trinidad where managers of certain state enterprises have then taken actions which have essentially brought the organization into difficulty or disrepute. The most classic one, of course, being the First Citizens Bank IPO, which was a couple of years ago. So with that, let me leave it here and we can pick up these points, I think, in the course of the discussion.